All right, good evening, everyone. Please, can you kindly confirm if you can hear me? Good evening.
Yeah, we can hear you.
Yeah, we can hear you.
All right, good evening. Thank you. Thank you very much. We'll be starting today's class. Welcome everyone to our first official session for data privacy and protection for the third and fourth quarter of 2024. You are welcome to class. Our topic for today is Introduction to Data Privacy and Protection. And I can see we have one of our mentors is already on call. Thank you so much, Matt, for joining. Without further ado, my name is Dennis Williams, and I will be your moderator for this session. So moving forward, we would just like to introduce our mentors that we are expecting for today's class. We are expecting 3 mentors for today's session. But so we'll just kindly go into reading their profile, and then we'll move on with the rest of the session. So moving on first. Moving on first with our first mentor for today, we have Mr. Ridwan Badmos. Mr. Ridwan Badmos is a tech lawyer, multidisciplinary privacy professional, and CTO. His expertise extends across various specialized technology law domains, encompassing artificial intelligence, blockchain, cloud computing, and other cutting-edge technology. Being a certified information privacy technologies with the LAPP and an esteemed One Trust Fellow of Privacy Technology, Ridwan is at the forefront of translating privacy regulations into functional applications that handle user data, a significant void he diligently fills. Furthermore, his unique position in working across numerous complex projects bridges the gap between legal and technical teams, thereby harmonizing 2 distinct domains in this expansive technology landscape. Ridwan adores for the effective implementation of privacy and security best practice is evidenced in his active involvement in shaping industry standards set forth by eminent organizations such as the National Institute of Standard and Technology, NIST, and Cloud Security Alliance, CSA, and the Center of Internet Security. Mr. Ridwan is not yet here on the call. He is running a little bit late, but I'm sure he'll be joining us soon enough. And when he eventually joins us, I'm sure we would have a lot to learn from him. So thank you so much, Mr. Ridwan. We're always happy to have you with us. Our second mentor that we'll be expecting for today's class is Mr. Solomon Okedara. Solomon Okedara, barrister and solicitor of the Supreme Court of Nigeria, is a practicing legal practitioner and researcher with over 14 years post-call experience and outstanding expertise in human rights with a special bias for digital rights, including data protection and privacy, data identity, online expression, intellectual property, e-commerce, tech, and corporate transaction, and artificial intelligence, having an unusual knack for excellency and matchless client satisfaction with a view to delivering maximal results armed with a peerless ability in creative legal research and analysis, delivering impressive results in review of law, legal principles, and standards. Solomon is a partner at Solomon Okedara & Co., a firm of barristers and solicitors, and co-founder Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promoting and protecting promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest and proven expertise in freedom of expression and digital rights litigation. He has litigated on digital rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court. He has conducted cases at the ECOWAS Court, amongst others. Solomon was in 2020 recognized as one of the top 50 individuals leading in legal innovation in Africa at the Africa Legal Innovation Awards. Solomon currently serves as the legal researcher with Columbia University in the city of New York for the Ivy League School's Global Freedom of Expression project, where he analyzes judgments bordering on freedom of expression, subjects covering over 120 jurisdictions across the world, including the United States, Europe, India, and Africa, amongst others. He is a 2016 Research Fellow recipient of International Center for Not-for-Profit Law, Washington, D.C. He was specially recognized in 2017 Heroes of Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize at Columbia University. Thank you, Mr. Solomon. Mr. Solomon is also not yet here on the call, but I'm sure when he's able to join, we'll be learning from his vast experience and his vast knowledge. He has been with us for multiple quarters and multiple sessions, and I'm sure our mentees will be glad and eager to receive from his wealth of experience and knowledge. Our last but not least on our mentors list for today is Mrs. Osas Benedicta Ezekiel Obazele. Sorry, Ma, if I didn't pronounce the last name very well. Mrs. Osas Benedicta is a distinguished legal professional with over 6 years of expertise in infrastructure, mining, oil, and gas law, with wealth of experience from both public and private sector, currently serving as a senior special assistant on legal matters to the Edo State Ministry of Infrastructure. In her current role, she provides pragmatic and strategic legal counsel, oversees contract management, as well as ensures regulatory compliance with the provision of the state's public procurement law and PFM Act. OSA's credentials include AI Career Essentials certification from ALX Africa, several trainings in public procurement, implementation and alumni status with the prestigious Mackenzie Forward program. Her skill sets encompasses contract review, policies drafting, strategic leadership communication, negotiation, and adept project coordination across various environments. She holds a Bachelor's of Law degree from the University of Benin and an LLB from the Nigerian Law School. Her legal acumen is evidenced by her successful negotiations of numerous contracts, safeguarding compliance and client interests. Furthermore, OSAS is committed to community service, having volunteered as a legal advisor for SME owners at the Faith Foundation. Her expertise in legal advisory, project management, contracts administration, policy formulation, and AI integration in legal processes make her a top-tier professional in her field. Thank you so much, Ms. Osas, for joining us. I can see you're already here with us on this call, and we can. And I will just say it is such a pleasure having you here with us. And not to waste any time, before we receive the presentation of our mentor, Mrs. Osas, who is already here with us, we would like to, because of timing, and I'm sure most of us may not necessarily have sufficient lighting in our background in a few may not have sufficient lighting in our background because it's evening, and the place may become dark very soon. So please, I would like to kindly ask us to turn on our videos on so that we can take a quick screenshot and for our public for our postings, and then we can carry on with class. All right, please kindly turn on your videos. We would like to take a screenshot now. Thank you very much, Chioma. Please, let's have more people turn on their videos. All right, we'll still take a few more. So please make sure your video is on. All right, we are done with that. Thank you very much. So Mrs. Osas, we want to give you the floor for your presentation. Ma, you have, I think, approximately 20 to 30 minutes to give us your introduction into today's topic. Like I said earlier, our topic for today is introduction into data privacy and protection, specifically covering principles and I think regulations as pertaining to data privacy. So Ma, the floor is yours. We would like to have your presentation now. Ms. Osas, are you here with us?
All right, good evening, everyone. Is a quick question, please? Is my slides going to be, brought forth based on I sent them, or am I going to share my screen?
I'll be sharing your screen for you. I'll be doing that right about now.
Like, will you be sharing my slides?
Yes, I'll be doing that. I'll be bringing up your slides right about now.
All right. Thank you very much. Good evening, everyone. Thank you so much. Great, huge appreciation goes to the JIIPCC Learning Institute for this opportunity. And I believe that this is not just feeding off. Instead, it's going to be a symbiotic relationship where we learn from each other. So going forward, we'll be talking about introduction to data protection and privacy. First off, for those that can hear, or if you can hear me, for those that had a private journal or a diary, to be more goofy, you write all your stuff inside, and you do not want anyone to see them. What happened to school, the person you had a crush on, the embarrassing moments, or just something, or maybe one of your inner thoughts. You would agree with me that you do not want that journal or diary to end up in the hands of someone you do not know or your parents, that's being said. And so you go through different means to make sure that that item is protected and secured. So either it has a lock or it's placed somewhere. That can be likened to our data at the moment. We are transiting into a world of technological advancement and evolution. And so that can almost be brought into this example here. We are all walking pieces of data that need security and protection with the topmost security entity ever, in order for us not only to keep us safe, but to keep our properties and our loved ones safe. So what is data protection? Data protection is the means by which we safeguard our data from corruption, compromise, or even loss. It can even get to a point that the protection can go as far as being able to restore information or data that has been compromised, rendering it inaccessible or unusable. So the concept of data protection is safeguarding your information, my information, from persons that we do not want access to. Now, data privacy, on the other hand, as I like to call it, information privacy, is another example of data protection. It is the ability to control the process around which the data is shared with third parties. It also analyzes how the data is used, where it is used. It concerns the proper handling of sensitive data, whether it's your financial data, your personal data, or your intellectual data, to meet standard requirements. Persons might think that, oh, but security, or should I say protection and privacy, seems to be the same thing. I see them as cousins, not twins, because in as much as they intertwine, they are quite distinct. And the distinction between these two is while one aims to safeguard, the other aims to control. So see data protection as a huge gate and see data privacy as a curtain or as a code. So in as much as I might be able to get into a building through the gate, I might not be able to see into the house, or because there's a curtain or there's something else there that is preceding me from seeing what is there. And so this is the importance of data protection and privacy today. Not only does it safeguard putting a gate over your data, it also secures whoever can see what is there. So either the person, there's someone that has, for example, a bank, someone can open but cannot enter. Someone can enter but cannot open, thereby rendering you secure and safe to the utmost ability of that entity that is striving to secure your data. Now, let's move on to the relevant laws that apply to us. Now, the Constitution is the ground. I call it the mother of all laws that we have in Nigeria today, because it was from it is the source. It is from it that it sprung other provisions. And Section 37 of the Constitution rightly provides for privacy. And in as much as some persons might argue, I also like to add the section on dignity, where someone's privacy is opened. It renders an assault sort of to the dignity of a person. So the Constitution, those sections are the ones for which has been generated this data protection. Now, this, aside from that, the other ones are the Data Protection Act, the Nigerian Data Protection Regulation that came before the Nigerian Data Protection Act, but then is now a supplementary of the Data Protection Act. We have the implementation framework, the guidelines, and then we have the General Data Protection Regulation. As it can be likened to a constitution, it is also the source from which Nigeria saw her lapses in data protection and sought recourse from the GDPR and thought, okay, how do we make this work? Let us look at other laws around what is attainable out there based on what standard, and then looked at the GDPR and thought to itself that, okay, we could try and get one or two out of this in order to form ours. And that is why I have put it here. The GDPR is not part of the Nigerian laws, but it gives a level of history to how we came to where we are at the moment. Subsequently, there are other laws, such as the cybercrimes law. Next slide, please. So we have the Child Rights Act, the Consumer Code, and the credit reporting. All these, they relate to these sections. They relate to several sectors in the country based on it. There's, for example, the Nigerian Communications Commission, if we have issues with breach of data when it comes to, for example, one of the telecom providers, we can use that. So we can see that not only are we sure of the protection that we have based on regulations, we can see that several sectors are being provided for when it comes to security of data. Now, if you notice, this protection, data protection and privacy, is one that has had a high octave when it comes to non-compliance recently, stemming from the recent fines by the NDPC, on Fidelity Bank, on its violation of data protection, and it has been fined one of the highest amounts that the NDPC has ever given, and that's a total of $358,580,000 because of violation of customer data or data within its confines. And so we can see the level, the rate at which the NDPC, which is the body that was created by the Act, is going to ensure that our data is being secured and is being guarded. So next on, we'll go to the key principles. These key principles, they are not all, but they speak to the major motto of what the Nigerian Data Protection Act is really talking about. It talks about transparency. Transparency meaning that whatever you're using the data for is what you're showing exactly what you're using the data for. There is no other thing you're using it for. You're not using, you're not, what's the word? You're not being shady. You are HOT, honest, open, transparent as to what you want to use the data for. Then we go to purpose and limitation. The limitation for which, the reason why you're using it must be limited to that purpose. So if I'm taking your data because I want to register your national identification number, I shouldn't also use it for something else. I shouldn't add you to my church WhatsApp group because I feel, okay, this person, let me know. That's already leaving the purpose for which I am collecting it. Not only that, there should also be accuracy. I shouldn't give you my data and see my name is spelled. I shouldn't give you my data and see that my date of birth or something else is incorrect. There must be accuracy. Accuracy also helps in making sure that the data that is being secured, you are sure, 100% sure. Now, for me, accuracy is not only for the data subject. We'll get to that later. The accuracy, which is the owner of the data, accuracy goes to the entity, the data controller or processor, to give it credibility. If it is not accurate, it makes the system porous. Also, storage limitation. There must be a time bound. The law will say statute of limitation. There must be a limitation to how long you can keep this data. So if I'm dropping my data with you, how long are you going to keep it? If I walk into the bank and you say, oh, I need to change my name, I need BVN, and I go and I print out the BVN, how long are you to keep that paper on your desk for? How long are you supposed to, if I go to school, how long are you giving my data for? If I go to the hospital, have an x-ray done or a test done, how long are you giving that for? So there must be a storage limitation. Is it 6 months? Is it 10 years? Is it, and so on and so forth. Then we have confidentiality. You must be ready to keep hold of whatever is being divulged based on what you're given. So religious status, we have abroad they will say sexual orientation, but here we'll talk about religion, tribe, because let's not be a sort of avenue to take advantage or leverage over that person. So you must be, whatever that person is telling you, oh, I'm this tribe, or age. Most persons, they do not like other persons knowing how old they are, so they want to keep it. Then if I am the data controller, I'm holding that information. I shouldn't go around telling the other person, oh, do you know that woman that seems so young, she's actually 50. Oh my goodness, she must have done PP or she must have done this. That's on the bright side anyways. But it's just to show you that there are key principles that fashion the data protection and privacy concept. Confidentiality, accountability. You must be accountable to whatever you're doing. You must be accountable. You must be ready to be accountable to whatever that you are safeguarding, the data that you are safeguarding, so as not to be rendered careless or negligent with people's data. This is very important. To sum it up, key principles that direct the provisions or the actions of securing data and making sure that data is being controlled stems from the principles that we just discovered or that we've just discussed. If these principles are not taken into cognizance, we'll see a flagrant misdirection or mishandling of data of data belonging to individuals. That's why we must take this into cognizance, regardless of where we are. For persons who want to be DPOs, as data protection officers, you have to take note of these principles. They are the ground norm. They are like your Hippocratic oaths, just that we have in the medical field, that will help you in your movement in data. And not only for people who want to be that, we as data subjects too, we must take this into cognizance, especially when you're going to a place that your data is going to be divulged. We must be very careful. Now I'm going to talk about the key concept. I deliberately omitted it here because I wanted us, but then I thought there'll be time, but there isn't. So I want to talk about the key concept, the key concept of data protection. These are definitive sections or definitive words that we may see in the data protection and privacy sector, such as data subjects. We all are data subjects. You have data, I have data. There are things you want to share. We all have, if you have an account number, your data is somewhere. If you have an NIN, your BVN, whatever, if you've attended a school, it's out there. So we all are data subjects. And so we must also know that this, when we talk about data subjects, we should just raise our hands up and say, okay, we are all part of this. Now, what is personal data? Personal data refers to things that are pertaining to specific individuals. What is then, I'm going to pick a name now. So Ms. Choma, her name, her age, her occupation, her school, everything that pertains to her is not the same as mine, because it is distinct to her personality. And so that's what we mean by personal data. It's our personal data. So when we put it side by side with mine, you can see the difference. These are two different individuals. Also, we'll talk about data controller. A data controller is the entity that determines the purpose of the process. For example, if I am going to the bank, I need to effect something has gone wrong, I go to the customer care. In order to process my data, they need something from me. And so because they need, for example, they need to change my name on my BVN, what they need and what I'm going to give is what makes them a controller. They're the one that are asking for that information. They're asking it. Then, for example, a data processor. I want to use INEC now. So just see, okay, I think this is going to make, okay, imagine that during elections, federal government is the controller. They need our data, so they need us to vote. So the processors are going to be INEC. And so they are going to process the data on behalf of federal government in order for, based on the constitution, in order to get someone elected into office. That is how a data processor is. So you have a data controller that is saying, okay, I need this from you. A data processor is the one that brings it out and gives it to the controller. Then we also have the people that they call data controller or data processor of major importance. Those are people that are resident here, managing the data of persons in Nigeria. Now, we're going to go to the importance of protecting data and privacy. And in addition to this, I will also mention some examples that have arisen out of the non-compliance of this, aside from the one I just mentioned. In as much as data is coming in and we're all rushing for a slice of the technical cake, we must also understand why. It's not because it's going to help us get work done or automated. It's to ensure that our rights as individuals, as data citizens, I like to jokingly say, as data subjects, are protected, are secured, and also ensures that there is trust in the digital service and platform. If you cannot trust your bank, let's just be saving money inside bottle, or what they call that, colo, like they say. Let's just, if you cannot trust your doctor, just go into the bush and pluck bitter leaf. But because there is going to be a presence of a robust data protection technique in several entities, it makes us trust them. It creates a trust, a bond between the entity and the data subject to say, okay, I can drop my data with you, I can do this with you, I can do that with you. So the importance of protecting our data and our privacy is that it ensures trust. It protects individuals' personal and sensitive information. And it's also in compliance with legal and regulatory requirements, which are important. And then it prevents identity theft and fraud. So you won't wake up one day and someone is assuming your identity. This you can mostly attest to in WhatsApp when somebody will say, okay, the account was hacked, this was done, and money is being extorted. This all arise out of maybe a mishandling of privacy. But then when we have an entity that is very good, when we have good protection and privacy of data, it will help in securing persons from theft and from fraud. Now, this brings me to what happens when there's a non-compliance with legal and regulatory requirements. And this happened between, I mentioned NYSC, where they publicized data of core members, and then they went to court and they said, oh, this was being violated. And then earlier this year in June, UBA was fined 8 million naira for violation of a customer's data privacy. And this is quite scary, because if this can happen, it shows that the importance of protecting our data and privacy most times is not hook, line, sinker, straightforward. We need strict policies. We need strict cognizance, attention to security of data and whatnot. Not only that, like I mentioned, imagine Fidelity Bank being fined one of the highest, in fact, it is the highest so far, because of this alleged violation of persons' data. So this is very important for us to take into cognizance: the importance of data protection, the principles that help it, the laws that are responsible, and then also the techniques and the key concepts that are embedded in this protection of data and privacy. In summary, we all must jump on this train of technological advancement, not only because we are afraid of being left behind, but because it is important that we know that which we are getting into. When we know how the system works, or know in some way how the system works, we have the capacity to understand and gain knowledge on how to protect ourselves and other persons from the consequences that can erupt from poor data management systems. Thank you very much. I hope I didn't exceed my time.
Thank you so much, Ms. Asas. No, you did very well in sticking to time. We are so grateful for that wonderful presentation. In very, very simple terms, you were able to help us run through the key concepts of data, privacy and protection, and just gave us a general overview. And we are really grateful. We're simple to understand. Examples. You were able to cover the topic for today. We'll be going on to other things, but before we do that, Mr. Ridwan joined us while Ms. Osas was speaking. So we'll be giving the floor to Mr. Ridwan for his introduction. Sir, you have 20 minutes for your introduction. Thank you so much for joining in. You're welcome, sir. Mr. Ridwan.
Thank you very much. Thanks. Yep. Sorry, can everyone hear me?
We can hear you, sir.
Okay. Just a moment, please. Yeah, I wanted to confirm if Mr. Kedara is, in the room, because I believe he's one of the instructors, or one of the facilitators today.
No, he's currently not with us. I'm not sure if he'll be able to join in, but we hope he is able to join in at some point.
Okay, If I may ask, do we have any other facilities?
Aside SIM, no.
Okay. Okay, that's fine. I mean, I would like to appreciate, I don't know, Mrs. Osas, I mean, for that insightful, discussion, even though I wasn't opportune to listen in from the beginning. And I also want to be careful of, saying those things that repeating what she has said. So I'm going to try to take another approach, so to say. So because I believe that's, the major thing I believe we were supposed to discuss today is, definitions of key concepts, principles, and some other things. So the approach I would like to take is going to relate to, I'm going to kind of, because I believe this is the first class, and it's also very important for us to, kind of take, for you to kind of, for you to really understand and for you to be able to kind of relate with these concepts and this field generally. I believe it's very important for you to kind of have a very good feel of, these concepts of this field generally. And the reason I also want to take a kind of personal experience approach is because, I wouldn't want you, most of everyone that is here, I wouldn't really want you to kind of go through the track. Is it the challenges that I actually went through when trying to learn these concepts, trying to understand it as much as possible in order to kind of apply it, to clients, to situations, because I think the ultimate thing here, the ultimate goal should actually be that ability to advise clients. But of course, before you can advise clients, you really need to understand. I think the first thing you really need to understand are, the concepts, the different terminologies, or the different topics that are really important, in this field of privacy and data protection. And then for you to be able to also understand, the kind of challenges or the kind of problems that, a client actually faces. And I believe all of us that are here are law students and probably your lawyers as well. So, but notwithstanding, I'm still going to talk about some technical things, because one important thing that we also need to always, think about is the fact that the reason why we have a proliferation of data breaches, or we have lots of privacy issues, privacy challenges, is actually because of technology, so to say. Of course, you will agree with me that technology is not the foundation of all this, of all these problems, because technology is this. Technologies are not kind of coming up. They are not. They don't just appear on their own. They are being developed by human beings. But of course, that's a process, or that's the fact that technologies, make things to the. If we don't have technology, so to say, which it's as a result of technologies that we have things called data, because we have that ability to gather lots of data generally. So so the essence of what I'm trying to say there, the point I'm trying to make, is that I'm going to be making a lot of references to technologies, how privacy and data protection relates to technologies, because most of the clients that you will be dealing with, interacting with, are they're going to be technology companies, to say, that process personal data, and how they actually use digital, because most businesses now use digital tools to process personal data, and most of them, of course, we still have the use of analog processes, probably documents, papers, to store the personal data, but still we have to kind of consider both. So, and you really need the understanding of, really need to understand these technologies to be able to know how you can prefer solutions, because it's not only about interpreting laws, what's NDPA, the Nigeria Data Protection Act, or the Nigeria Data Protection Regulation, or any other guidelines that the supervisory authority, which is the NDPC, is issuing or releasing or publishing. But you really need to understand how to really apply them to specific situations. So, of course, the first thing that you really need to do, and that's why I again appreciate our first speaker, is I really need to understand all this, what they mean, and not just to understand them by knowing their definitions and taking them to art, but not just knowing their definitions, but of course taking them to art, I would say. So you really need to understand, and because you really need to understand all these concepts, all these steps, because there are some instances where they could actually mean something else, so to say. I hope you're going to get what I mean by that, before I finish my talk. But to make everything kind of streamlined, because I don't have a presentation to present, and that's for obvious reasons. Hopefully, probably in the next classes, I will have a presentation, because this is a kind of introductory class, and I want to kind of make it, if it's possible, to make it interactive as much as possible. And I also want to have that opportunity to kind of talk about it as they come. So the first, I mentioned a lot of things about what you really need to do. I mean, the kind of foundation that you really need to be able to kind of have that capability to provide legal solutions. I mean, effective legal solutions to this, which is understanding the terms, understanding the concepts, and seeing how they kind of work. And one or two ways that I'll say you can actually do this is not just restricting yourself to your local area. I mean, your local jurisdiction, because there's a lot of the way I see privacy is that we all know that it's a global issue. It's not just and that's why every country has to, and that is why you will see that we have countries that have they have list of countries that you can transfer personal data to, and you might not be on that list because you don't have adequate regulations, data privacy or data protection regulations. So that's the reason you really need to. It's cut across borders. So you really need to look at how other jurisdictions kind of look into this particular field. So the first thing I would like to say, trying to be specific now, is to talk about those terms that you really need to understand. Of course, you need to understand personal data, and the reason I said you need to understand personal data is because clients work with, because I also operate a data protection compliance organization. Those are entities that are licensed to perform or conduct data protection audits on companies. And one of the things, when we were kind of interacting with that particular clients, they said they have a lot of things. They have privacy policy. They have even DPIA, to the extent of them having processes for data protection impact assessments. Those are the things that we need to understand as well. So, and there was a particular question in our questionnaire that we said, does their management understands what personal data is? And the answer was no. That was, if they had come back to ask us that, what do we mean by this question? The question was actually very straightforward. It would have been another story, but they answered no to not knowing what personal data is. That's, everybody will agree that is most basic of all the terms in data protection, in the data protection space. So it's really important to, and it's, aside your understanding that personal data, it encompasses your name, addresses, all these kind of things. You really need to understand the definition, so to say, and what might fall into that definition, in the sense that anything that can personally identify a person, so to say. Just to give you a rough definition of what the personal data is. But then another thing that you also need to understand is that's the reason I said you really need to look at other jurisdictions, because you will find other jurisdictions calling personal data PII, personally identifiable information, and or personal information, in short. So you need to really know all these things, and how they kind of interrelate, how they can be used interchangeably. And the thing is that privacy is also a living it's a living issue, so to say. I mean, in the sense that we're talking about issues that, challenges or problems that people, have with technologies every day, in terms of how technologies or company kind of process their, personal data. And that will take me to that, that's approach that I was talking about, which is talking about how you can also learn about technologies. I mean, you would have had, I will go to those concepts now that are also kind of important, that you won't really find lawyers talking about a lot, because I kind of have a technical background as well. So aside being a lawyer, so I enjoy learning technologies a lot. So I can say I'm a cloud engineer, a software developer, a blockchain developer as well. And because of that, I have a lot of interest in things that are called, you would have had terms like privacy by design. Right? I don't know if you've had, can you signify if you've heard about, okay, let me start from the privacy by design. Has anyone, do you know what we mean by privacy by design, or do you, have you come across the principles of privacy by design? And if you have, could you signify how many, privacy by design principles we have? You can talk, or you can just put that in the chats.
Okay, mentees, please, can we respond? Please, Mr. Ridwan is asking a question. So please, if you had the question and you would like to give your feedback, you can kindly unmute yourself. And you can also send the answers to the chat box. So please, if anyone has an answer, right, kindly do that.
Okay, can anybody hear me?
Yes, I can hear you.
Okay, privacy by design is the inclusion or the implementation of privacy or protection into like developments of systems or technologies. So basically what it means is that, for example, in the Internet of Things or emerging technologies, privacy has to be highly considered, because these technologies are basically taking our information and our data. I would like to throw reference to the smartwatches that we wear. They are configured to take our health or any other analysis in our body. So that is why they can track our steps. They know our heartbeats. They know when we are feeling anxious or some any type of way. So privacy by design is literally implementing or including privacy systems into these devices or into these machines, so that they protect our data. I don't really know much of the principles, but I know that some of the principles of privacy by design would be end-to-end protection. For example, we have WhatsApp that has end-to-end encryption. So it's basically saying that this your information that it is taken, it's protected within the system. Within nobody is allowed, like nobody can hack, is allowed access into it. Another one I would say is it is a default setting because of the kind of data that this technologies process. Privacy has to be like number one, has to be the first thing, that because we don't know the kind of people that will have access to the data. Then another one is to allow it to be functional. It should be functional enough. It should be a working system. It should be not to be something that maybe today you hear that, oh, they hacked into it, or tomorrow they did something to it. It should be functional. It should be something that's that is able to be trusted. I don't know if that's a better way to put it. So basically, privacy by design is just implementing privacy into technological designs and every other system. Yeah, I don't know if that's.
Yeah, that's fantastic, Chema. Thank you so much for that. It's very insightful. So I really have you're actually the additional thing just like mention is that
Mr. Ridwan, we can't really hear you clearly.
okay. Can you hear me now? Is it better now?
Yes, it's better now.
Yeah. Okay. So I was commending Mrs. Chairman that's actually accurate. I mean, what she has. And I said I really don't want to go deep into this. And it's hopefully in one of our subsequent classes I'll talk more about it. And the only thing I just want to mention as regards privacy by design, that's you need to. I would really like if you put that in mind and consider it. One of the things I would like to say, maybe I should just break that down into two, is that ordinary. I mean, as regards lawyers, you would you would think that what you just need to do is to kind of just understand the laws, understand what's NDP and NDPR and other guidelines says, and then try to explain that or try to advise your clients accordingly. But you find that there are other instances where you have to do more than that. Maybe you're acting as a DPO in a company, because we have lawyers, lots of lawyers now acting as DPOs. They're even the first set of professionals companies will hire as data protection officers, or you will have them as privacy analysts, or you will have them as chief privacy officers, along their career progression. So because sometimes you might think that privacy by design is not a concern of the lawyer, but it really is. And the reason I say that is because of when you're talking about privacy by design, what it really entails. And that is because it is foundational. Privacy by design actually talks about you considering privacy from the beginning of your system's development. So meaning that you have to start considering privacy from the beginning of designing a system. I'm not even saying building or developing a system. I mean, when I mean system, I'm talking about applications, products, anything that's that will kind of process personal data. So you really need to, because, and if you are familiar with software development, there's something called SDLC, software development life cycle. That's the end-to-end process of you're developing a product. I mean, when I'm talking about products or applications, I'm referring to things like WhatsApp, even your CUDA application, your GT Bank applications. They're all products. So, and there are different ways of kind of building those kind of products. So, and it starts from requirements that what you need to build that product. So, where the requirement gathering could include you, looking for, trying to ensure that the application you're building is viable, that it's really solving a particular, really solving challenges, specific challenges. And so why would you now start, looking at why kind of considering privacy from this stage, which is the beginning of a product development, is because you really need to start, thinking of the information to gather, how to even reach out to, because sometimes you will have to talk to users, the people that even they are not users yet, but they're going to be the future user of your product. So you're going to talk to them, and you even need to probably think about the information that you can actually get from them. And not just that, that's even the external thing. But then you will start thinking about how you want to, build the products in terms of how that product is going to process personal data, and how the things that you really need to do, that you need to communicate with the designers when we're talking about UI UX. That's the people that designs if it is a wireframe, or if it is the first. Sorry, I'm turning this into a kind of software development class, but the reason I'm also kind of talking about all these things is because you will work with developers a lot, or a technology company, and if you don't tell them this, I mean, if the best way to actually prevent, there are two ways I think that I can think of now that's actually the best way to prevent a data breach or a privacy issue from coming up. And that is number one, privacy by design, doing this thing. I mean, starting from the beginning to consider the privacy implications of what you're trying to build. And on the other hand is when you've built it, and then you use some capabilities called privacy enhancing technologies. And that's where privacy engineering comes in. But we're going to talk about that. Probably, hopefully, I will probably touch upon all those concepts. And in subsequent classes, I hope to, kind of extend it better. So, but talking about, so those are the two, I just wanted to really mention that's actually the best experience. I mean, when you're processing, I mean, internally, I'm not really talking about how, of course, if lawyers advise and clients stick to those advice, of course, that's one of the ways of preventing. I'm talking about processing now in terms of technology. Sorry for, the really nitpicks. So we're talking about privacy by design. And as I said, just to reiterate before I move on, is that what it really entails is you considering privacy from the beginning of the product development. And there are 7 principles, and you really need to look at those principles. From privacy by design is also one of the principles. Designing privacy into from the design to the architectural development of the products, to even the design when they're designing. I mean, when UI/UX designers are designing, they really need to kind of look into the private, how they are going to design the application, kind of to ensure that it's not, because when we talk about there's this particular topical issue I want to remember, which is one way of okay, let me just put it this way. You could say, maybe your privacy notice, you're saying that this is what you do, and in the real sense, that is not what it is. Probably, okay, I'll give a very simple, a very relatable example. Let's talk about cookies. So when you're designing an app, and you're not, I mean, the designer is not thinking about a way that you're going to make the collection of cookies to be transparent, to be known to their users. Then that is one way that you can actually violate privacy requirements or data protection regulation requirements. So that might not be very clear to you, but what I'm trying to say is that when you advise your clients, they're actually the one that's going to kind of build that capability into their the products, into what they're selling, their software. So if you as a lawyer, if you don't really understand how to probably, of course, it's not really your work, but of course, you're trying to build this company together. So you might, if having a bit of insight, I'm not saying that you should learn software development or you should learn all these technical things, but having a bit, because that's really what lawyers should be. That's why they would say you have to be kind of business, is a business conscious or business centric. You understand business, understand how to be able to understand to advise businesses appropriately. What I'm saying in essence is that you really need to understand a bit of different departments to be able to kind of advise them effectively. So going back to privacy by design, so you really need to understand, just, I mean, even if it is just to read through, the what's it called, the principles, the 4 or the 7. I'm sorry, I'm being distracted here. Yeah, so I'm sorry, I have my baby with me and my mom is not around, so I'm just trying to what's it called? So just here with me. So so I was talking about the essence. So you can just go through all the 7 principles to understand what's the privacy by default is also an example. And Chama also mentioned end-to-end security. So there's a lot of things, and the last one is actually being user-centric or being respecting the privacy of your users. So there's a lot of things that goes into privacy by design, but the major point that you just need to put in mind is the fact that you need to kind of you need to consider privacy from the beginning of a product development, and that is where DPI also comes in. So DPI should be one of the tools for privacy by design. So DPI is data protection impact assessment. And ordinarily, as required by law, you need to conduct a DPI before you can build any new features or any new applications. So meaning that you need to look at how your application or the new feature you're building into your application is going to affect your customers' personal data. So we have 4 processes mainly, but we won't go into that. And I don't know, Dennis, please, how many minutes do I have more so that I won't take all of the time?
All right, sir. You have 5 minutes left, sir.
Okay, great. So I'll use that to also explain things like privacy engineering and pets. And the reason I'm talking about all these things that are not even, that are not really kind of integral, so to say, but they're actually integral in the real sense. Integral to what I mean by that is that they're not part and parcel of privacy laws from the beginning. But we really need to face reality in the sense that these things are because we need to explain. I mean, I'm talking about privacy engineering and pets now because they are both engineering or technology terms. When you're talking about privacy engineering, it actually means you will see the statement or the term is made up of 2 words: privacy and engineering. It's actually engineering privacy into your systems, your applications. So what that means is that all these requirements of law. So how do you ensure that your technology, your products, really, kind of align or comply with those requirements? And that is why you see on WhatsApp, you would have been seeing different features that are privacy focused or privacy enhancing, so to say, in terms of how you can delete information or chats that you send, how you can block someone, or how somebody will not be able to see that. All those things are privacy. So so it's engineers that are actually building those capabilities. But of course, lawyers need to kind of explain to them, or even after they've probably built it, you need to kind of assess those capabilities, those features, those functions that they're building, if it really aligns with its privacy requirements, or if there are some things that they still need to look into. So that it is actually functional. So you just, as lawyers, we just shouldn't be there to say that, okay, this is what the law says, and then and then your client is on their own. They need to think about how to do these things. And when we talk about privacy engineering as well, as I said, it's kind of understanding. It has 2 things involved. It's kind of understanding. It's really understanding privacy relations, just as lawyers, and trying to now kind of build that thing through engineering mechanisms or techniques into your systems. So it brings 2 domains together, and that is actually where I'm kind of building myself in, or that is my domain, so to say. So, and we don't have a lot of lawyers going into that. I can only think of one lawyer, I think, Jason Crunk. You can look up the name on LinkedIn, Jason Crunk. He was a lawyer. I'm not sure I don't think he's still practicing. So he's the only, but I believe there should be more. I know another person who founded, not NOIP. I mean, NOIP is a big organization in the EU. You can look that up as NOYP, all in small letters. I think the meaning of that is not none of your business, so to say. So that's if anybody knows Max Schrems, you're all supposed to know Max Schrems, or who knows Max Schrems. You can signify maybe by raising your hands or by putting it in the chat. So you can look all those things up. I think Max Schrems was a lawyer. I'm not very sure. But then he also do some bits of technical things. But what I'm just saying is that if without you bringing those 2 areas together, you can't really have complete privacy capabilities. And so engineers and lawyers really need to work together, privacy counsel, to kind of build, or to kind of prevent privacy breaches, to kind of build privacy capabilities, and other things that we would kind of talk about along the way is we're going to be talking about privacy culture. We're going to be talking about how to really make privacy functional and not just give advice, and that's all. And when we talk about pets are privacy enhancing technologies, I think I'll just use that as a kind of aspect to all. If you could look it up, and you can always reach, maybe in our next class, you can talk a bit about that if it's possible, but I'm not sure if it's going to be possible. So you can just reach out to me if you're interested in these areas. And as I said, I'll still reiterate that you don't really need to go into software development, because it is very stressful. I mean, that's the part I took. It's not something I regret. I'm not regretting that, but I wouldn't advise anybody, if you're a lawyer, if it's not that you want to transition into the tech space, the tech industry, I won't advise you to go deep, because it's a loss for you already. There's a loss for you to learn under privacy regulations. There's a lot of terms you need to understand, because those terms are also, they are overloaded, so to say, sometimes, because we continuously have different definitions of personal data. So there's no generally acceptable definition of personal data, because sometimes you'll find in some areas you'll find some information that are termed that are interpreted to be personal data, and you find in other jurisdictions that they are not. And some other time you will find that some other type of information are now categorized as personal data, and that supposed to be the simplest term in the privacy and data protection space. So you can look up what privacy enhancing technologies are, and I mean, you can always, oh great, that's nice, you know about the terms decisions. So you can look that up, and then you can reach out to me directly, and I'll be really happy to continue the conversation. There's a lot to talk about, and maybe that's one of the reasons maybe I'll start preparing presentations so that I will kind of be restricted to talk about the specific things. So I think I'll just stop there. Or the other thing I'll do, if I have 2 minutes more, the other thing I would like to talk about is the principles and data subjects. Okay, 3 things, sorry. I just want to mention it because they are quite important as lawyers to really understand those concepts very well. When I got it, I think it was the next thing that Mr. Fass was talking about. I think she was talking about data protection. It's quite important. And the other 2 things I wanted to mention is a legal basis. We have 7 data protection principles. We have 6 legal bases. And then we have, I don't know if it's 7 data subjects rights. So all these 3 things are actually very, very important. They go deep into the legal terrain of data protection. So when we're talking about data protection principles, we're talking about lawfulness, transparency, and fairness, or whichever way you might want to arrange it. That's actually the first data protection principle. That's if you want to process personal data, it has to be lawful. So you must have I always like linking that up with the legal basis you have processing personal data, which are 6. You would know about consents, provision of services, so to say. You know about legitimate interests, public interest, and the likes. Okay, I think the one of when I was talking about provision of services, I'm actually referring to contractual obligations. So you need to look that up, legal basis. What that actually means is what is the legal basis you have for processing personal data, in the sense that you must be able to identify any of those legal bases before you can process data at all. And I think I was explaining this. I don't have any more time. I was explaining a bit of this to the blockchain class yesterday night. But then I'll just continue with my principles. So I've mentioned the first one, and that was the reason I went back to legal basis. And when you're talking about other data protection principles, you also have to talk about purpose limitation, which is that you can't process personal data beyond the reason you've collected it. That's the second one. The third one should be, I believe, data minimization. I like putting data minimization before the storage limitation. When you're talking about data minimization, it means that you can't process, you must not collect more data than you need, than necessary. And that does not mean that because you said that these are the reasons that you want to collect, these are the reasons or the processing activities that you will be using. And that's another thing that you need to learn as well. Data processing activities, very important. So because you've said that these are what you're going to be using the personal data you're collecting for, you can't say that, okay, that's fine then. That is where privacy by design can also come in the sense that you ought to look at the fact that is this, I mean, if we have all this, even if this is what we're going to use the personal data for, is it really necessary for us to collect this personal data? Is there another way that we can collect less invasive, set of personal data sets without collecting this? Or can we even do without, can we even provide these services? Or can we even do this, perform these functions without collecting personal data at all? So all those things really need to, and that is, DPI will also come into that. So you see that all these concepts, they actually interact, the kind of, enter one another, so to say. So, and then the next one will be, so I've talked about data minimization. The next one is going to be storage limitation, which is, Mr. Sass has really talked about this. I don't think I need to add anything, which is also called retention. So you have, so I will talk about that. So what retention means is that you should have, you can't retain personal data beyond beyond a kind of retention schedule. You must have a retention schedule for keeping data. Maybe when your customers, when somebody's no more a customer, you have to delete the personal data immediately, or maybe you have to keep it for like 3 months if, in case any issue comes up, or because of your of regulatory provisions, or like the financial space. I mean, I'm talking about banks and the likes. So when I'm not transacting with the bank again, I don't use the bank again. So they can't delete my personal data anymore. So that is there's a kind of limitation to how data retention can actually work. I don't really want to go into that beyond this because we don't have enough time. And then the next one, how many have I mentioned, please? Can anybody tell me? How many data protection have I mentioned? Data protection principles have I mentioned? If you're counting.
I think you've mentioned there about 5, sir.
Okay, great. Thank you very much. So I think the sixth one is going to be okay, that's going to be, of course, the cybersecurity triad, so to say, not all of them, but I'm talking about confidentiality. If you're talking about cybersecurity triad, we're talking about confidentiality, integrity, and availability. But of course, here we have confidentiality and integrity. So meaning that that's where more of cybersecurity comes in. So you can, and that is where we also need to differentiate privacy and cybersecurity. And that is also where the issue of fidelity will come in. When people say that, where's the data breach? Were there a kind of cyber attacker incidents? But I don't think there was any, I mean, as according to what I read. So it wasn't as a result. It was a privacy breach, not simply a cybersecurity breach. So if you're not informing, if you don't have a privacy notice, that's a privacy breach. If you don't even perform a DPIA, and you know that you're supposed to perform a DPIA, so to say, that's a privacy breach. So there's a lot of privacy infractions that you might come up with that might not even be related to cybersecurity incidents. So you really need to understand. But what we mean by confidentiality and integrity is, those cybersecurity measures. That's why we talk about terms. You will know about technical and organizational measures to ensure that you're protecting personal data. So it's not only about protecting personal data. There's more to it, and that is why we've started with almost 5 before coming into confidentiality and integrity. And then the last one is accountability, which is taking initiatives to ensure that you're protecting personal data or you are complying with privacy regulations. And the other thing that I won't even touch at all is, as I said, the data subjects' rights. So from access to deletion, or to even ADM. What's that called again? Who can tell us what is ADM, or is this AGM? I believe you know what I'm. Okay, it's ADM. What's ADM, please? Who can tell us? I'm ending with that, but I just want to hear your voice before I finish up. So who can tell us what ADM is? I mean, as it relates to data subjects' rights. That's the rights of of citizens, I'll say, in relation to with privacy, in relation to privacy. I hope you all have my question. Who can tell us what ADM is?
I'm sorry, please, can you I didn't get the question.
Okay, I was asking what ADM is. Is one of the data subjects' rights. So ADM is. I mean, I just want you to really kind of remember that abbreviation. Okay, ADM actually is an automated decision making. Yeah, so you have your data subjects have rights to opt out of using automated decision making to process their data, so to say. Kind of maybe if you're I said I won't say more than that. So that's ADM. It's one of the can look it up. It's one of the data subjects rights that's a customer or a data subject has. So I'm going to be stopping there. So I mean, with all this that I've said, I mean, we know that there's a lot to learn, and it's not, you can't just stay on your lane, on the legal lane, legal terrain alone. You have to really work with other people to ensure that you're providing maximum benefits to your clients generally, and even to the, because I mean, it's also about you. It's about your personal data. So anybody that you know could actually be affected. So you really have to, and that's actually the best way to also kind of build the culture in a company, to let people understand why privacy is very, very important. It is very, very important, because a lot of things could, I mean, Mr. Sass has done just that as well. So you need to read a lot of books. As much as you read, you will really understand the huge essence of privacy. Thank you very much.
Thank you so much, Mr. Ridwan, for that introduction into today's topic. So without wasting any time, please, we'd like to have our presentations from our mentees. The time for presentation is 7 minutes. So please, I would like to request that you kindly stick to time. Right. So group one, please, if you're ready, you can come up with your presentation, share your slides, and let's have presentations. So group one, please make your presentation. After that, our mentors will be giving feedback to your presentation, and then we'll be taking question and answer for the session. So please, group one presenter, you can come up and make your presentation. Group one presenter. All right, thank you, Chioma.
Good evening, everyone.
Yes, good evening.
Can you hear me? Can you see my screen rather?
Yes, your screen is visible.
All right, thank you. Okay, I want to say thank you to our mentors that have been able to give us a brief introduction as to what today's topic is all about. So my group and I were able to briefly put together this slide to our own understanding. So our table of contents is going to be introduction, definition, legal frameworks, case laws, key concepts, and principles. So moving to introduction. So what is data? Data is basically your name, your date of birth, your house address, your age, your medical records, your health reports, anything that can be used to identify you or anybody else's data. Basically, data is a noun. Data is the name of a place, animal, place, or thing. So data is figures, numbers, anything that is used to identify any person. It was described by the economists as the oil of the digital era, and it's just it's just considered valuable by tech giants and Google and the rest. So going to definition, our first mentor already gave us a very clear definition on data privacy and data protection. She described data protection as a gate used to safeguard your information, then privacy as the curtain that helps to control. So often it is used interchangeably, but they are not the same. Data privacy is a right under the Constitution of the Federal Republic of Nigeria, as amended, Section 37, and it basically gives data subjects or us ourselves the rights for our data to be protected. While data protection are more like, okay, I think that would be the next slide. More, data protection are the mechanisms or the measures or procedures that are used to protect our data, that are used to protect our personal data. And we have the legal framework. So I like to divide these legal frameworks into number one, regional and worldwide. So regional, we relate to us here in Nigeria. So regional meaning in countries, the legal frameworks that are used in each country. So for us here in Nigeria, our regional frameworks are the Nigerian Data Protection Act, the Nigerian Data Protection Regulation, Freedom of Information Act, I think our first speaker listed out some constitution, the guideline for management of personal data by public institutions in Nigeria and the likes. So every act we have in Nigeria that provides either broadly or specifically for data protection are our regional frameworks. Then we now have our worldwide frameworks, which is the European Union General Data Protection Regulation. So this is more like the source from which, if not all countries present in the world, they drew their inspiration for data protection. We have, like I mentioned here, the Data Protection Act in Ghana, and the like. So I also have, industry association that set standards for most of their bodies on how data should be used. So, for example, we have the Payment Card Industry Data Security Standard, which requires that all payment platforms should process credits that comply with data protection. So, those are the legal frameworks. Then we have others, like I've mentioned, the Child Rights Act, the Freedom of Information Act, Cyber Crimes Act, CBN, Central Bank of Nigeria Consumer Protection Act, the Credit Reporting Act, and the National Identity Management Commission Act. Then key concepts. Number one, who are data subjects? Data subjects are identifiable persons, naturally identifiable persons that who have data. So like our first speaker mentioned, all of us are data subjects. We have names, we have date of birth, we have addresses, we have everything that can be used to identify us. We are data subjects. Even companies are data subjects as long as they have data. Then we have personal identifiable information. This is any kind of personal data or information that can be used to directly or indirectly identify a person, such as your email address, your phone number, your BVN, your NIN, and the likes. Then we have sensitive data. These are data that that's basically divide the person either by race, by culture, by sex, by beliefs, and the likes. Then we have data controllers. What are data controllers? Data controllers are those that basically determine how data should be, that basically control how data should be processed. So we give examples here: a bank, a university, an employer, and like our first mentioned, federal government is the data controller. They are the one that collect data and they control how the data should be used. Then we now have a data processing. It is any kind of dealing with personal data, such as obtaining, recording, using, storing, categorization, transfer, deletion, preservation, adaptation, and the rest. Then we have data processors. These are the bodies or entities that help to process data on behalf of the data controllers. A good example was the INEC that was used by our first speaker. She mentioned that INEC are the ones that process the data for election purposes. The federal government collects the data and they direct that INEC should process the data just for voting and election purposes only. And we have the principles of data processing. This is outlined under section 24 of the Nigerian Data Protection Act. One principle is the principle of transparency. This requires that personal data should be processed in a manner that is transparent, lawful, and fair. And the data controllers and processors must be open and must be clear about how they are processing the data. There must not be any shadiness or any hidden agenda to how the data is being processed. The example we gave here was the recent FCCPC and NDPC investigation, which involved Meta and WhatsApp. where they were collecting data that was not specified in their privacy policies, and it was being used to process online or other than what they told us for. So this is the principle of transparency. They were negligent in being transparent on how much data they were collecting, and as such, this led to the investigation carried out by the body. And we have the principle of confidentiality. This also states that the data must be, the data processor or data controller must use appropriate technical measures or security measures to protect the data. So either encryption, anonymization, like we have end-to-end encryption, or replacing the data with with general names. So for example, instead of saying Shoma, I can say Mr. B or Miss C. So that's it. Then we have principle of security. I think this is also outlines with confidentiality. It must you must protect the data against unlawful access. The data must only be given access to those who are meant to handle the data. So we have here, the example we have here was the GT Bank website outrage that currently just happened. I don't know if anybody heard of that, where it was rumored that their website, the GT Bank website, was down because it was hacked by hacktivists. So we have also we have here the Olumide Babalola vessel. So Olumide borrowed money from Sokolon, and Sokolon had access to his contact and sending them messages that and threatening messages that Olumide should pay back the money. Then other principles include accuracy. So your data that you've collected must be accurate. It must be complete and not misleading. I cannot give you my data, and when I need it, you're spelling my name incorrectly or you're getting something wrong. You must be accountable for the data you have collected. You owe a duty of care to the data subject, to know that to make sure you let them know how the data you have collected is being used. So another example we gave here was the NIMC putting out a statement debunking that the NIN was being sold. We had all heard that our NIN was being sold on the black web for as low as 100 naira. So you must be, and when they put out that statement, it showed accountability that the data as rumored was not sold on the black web. Then we have minimal storage or retention. In your privacy policies, you must specify how long you're keeping your data for. If it's 3 years, if it's 3 months, it must be specified how long you're keeping your data for. So you must not keep data longer than necessary. You cannot say, oh, maybe I'll use it in the future. No, you must keep it. It must be during a specified time, and it must not be unspecified. Another one is principle of consent. Consent must be clear and unambiguous. You must make sure that your data subjects give you consent to process their data. This is why even when we open apps or websites, we are required to tick the little boxes that we see. You cannot move forward if you do not tick those boxes. That is showing that you have consented that they will use your data for the specific purpose with which you're submitting your data for. So we have our question. So number one question the group generally asked was, what is the difference between data protection and privacy? And what courts should be approached where there is a data protection violation under the NDPA? And do dead persons still have the right of data privacy and protection? And in a university or school, how long should the personal data of ex-students be stored after they leave or graduate? So in a nutshell, what Group 1 has been able to provide are what is data, and explaining the concept of data privacy, such as data subject, data protection, data controllers. Number 3, we've been able to also explain the principles of data privacy, such as accountability, limited purposes, lawful basis, and confidentiality, security. And we've also been able to give examples that borders on these concepts and principles. Yeah. Thank you very much.
Thank you so much, Chioma, for that wonderful presentation. You did very well, and you tried your possible best to keep to time. Well done to you and to the members of your group for putting together that presentation. I'm sure our mentors listening and paying attention, and will be getting feedback from them very soon. But I would like to request that if it's possible, you can put the questions that you have asked in the chat box, so that once we are done with the presentations and the feedback, we can go straight to that, and our mentors can treat it, because I don't think they may be able to remember based off of your presentation right now. So please, you can copy that and put it on the chat box. Thank you. So we are going straight to Group 2's presentation. Please quickly start sharing your screen. Start sharing your screen so that we can have your presentation. Like I said, you have 7 minutes. Try and stick to time. So who is okay? Where's the presenter?
Good evening, sir. I am presenting for Group B.
All right, that's very fine. Please go ahead and share your script and share your slides so that you can carry on with your presentation.
Okay, I'm trying to do that right now. Okay. Okay. Yes. Okay. Sorry, can we see my screen?
Yes, your screen is visible.
Okay, good. Okay, good. I'll start now. Okay. Good evening, everyone. My name is Olorunfemi Akindite, and I'll be representing Group B for this 7 minutes presentation. So our topic is Introduction to Data Protection. So first of all, I would start by defining data protection. So I'll start by defining data privacy. So data privacy refers to a person's right, basically refers to a person's right to disclosure or selective disclosure of his or her personal information, of his or her personal data. So now to just give a brief context to data protection and privacy. So in the world we live in right now, organizations increasingly demand for data from consumers, and this this is only projected to increase as civilization advances. So as a result, there is a need for a framework um, that that alleviates the risk that is posed by um, this data this data getting exposed to hackers and then manipulating, commercializing, and using it for illegal activities. So this is where the data protection framework comes in, and this is where the GDPR, the Nigeria Data Protection Act, Nigeria Data Protection Regulation comes in. So on the screen here, we define data protection. I will say that data protection ensures the fair and proper use of personal information, safeguarding individual privacy. So I've talked about the modern context. To the next slide. So the importance of data protection is the first one is that it ensures trust and integrity, because when if there is no framework, if there is no structure to protect people's personal information, people will be unwilling to submit their information to that organization, and it will allow them to lose trust in that organization. And there's also business impact, because an example of a data is like sensitive information, certain sensitive information that belongs to organizations. They are protectable under data protection, and if there are leaks of this information, for instance, trade secrets, it could be detrimental to a business. So next slide. Okay, definition of privacy. Okay, I've defined that. So let me just talk about the legal framework briefly. So the legal framework of data privacy. So the legal framework of data privacy and protection. So data privacy and protection originates or emanates from the right to privacy under Section 37 of the Constitution of Nigeria, CFR 1999, and the and that that section provides for the right to privacy, how that a person's right to private family life, correspondence, everything is protected under the Constitution. Then, by extension, the Nigeria Data Protection Regulation of 2019 provide certain guidelines for data controllers to provide security measures to ensure that there are no leaks of PII, personal identifiable information, to ensure that companies or organizations, data controllers create measures like encryption technologies, firewalls that prevent breach of data. So we also have the most recent Nigeria Data Protection Act that was signed in 2023, which is very comprehensive. So, okay. So this concept, okay, legal basis, I've talked about that. So now to the principles of data protection. So the first principle here is lawfulness, fairness, and transparency. This simply means that a data controller or an organization who has access to the data, to the personal data of consumers, must ensure that it lets the users know that they are with the data, and it lets them know the purpose for which the data is to be used. And if there is any subsequent change, for instance, by third-party licensing in the way the data is being handled and managed, the users must be informed. So the next principle of data protection is purpose limitation. Please, am I heard? Can you hear me? Answer confirm.
Yes, I can hear you.
We can hear you.
Okay. So the second principle of data protection is purpose limitation. This means that data data must only be collected. This means that data must be collected for a definite use, and that data that is collected must be applied for that definite use. So when you collect data for a particular use, for example, for hiring a particular, like an employer, collecting certain information from a potential employee, when he collects that information must only be used for for that particular activity of hiring the person. So the next is data minimization. So data minimization, this principle of data minimization requires that the least amount of data necessary to achieve a particular use, like an organization or a data controller should only collect the minimum amount of data required for a particular use. That is, it should not go overboard in its request for personal data, things that do not relate to that particular use, should not demand for it. So the next one is storage limitation. This simply means that a data controller organization must, when keeping or holding that particular data, must hold it for a period or a time frame necessary to achieve whatever purpose he wants to use the data for. So let's just go on. So principles explained. Okay, I've talked about that. So okay, now to the key concepts in data protection. So key concept in data protection is referring to the terminologies in data protection, like certain essential terms, concepts that must be known. So the first is data subject. So this is data subject basically is any individual whose data is being processed. So it is any person, it refers to an individual who is identified by a particular data. That is where data subject is. So before I talk about data controller, let me talk about personal data. So personal data refers to any information about a person, what the person does, where the person lives. In fact, anything by which a person can be identified is a personal data. So data controller is anybody, any person, any organization that is responsible for safeguarding, monitoring, or deciding how a particular data is to be used. So a data controller does not have to be someone that puts it into use. Merely having data in your possession makes you a data controller. So pseudonymization refers to the process of the identifying a data such that a link cannot be reestablished between the person who the data subject who would have been identified by that data, if not for the process of pseudonymization. So next. Okay, talking about that. The key principles. Just talking about that. okay, emerging trends in data protection. So this is talking about some strategies that are being used that are being used by corporations, by organizations to protect data. So the first is hyperconvergence. It refers to an integration of compute networking and storage infrastructure. This is so as to promote efficiency and also like scale up security measures. So they integrate a lot of measures to ensure the effectiveness of the data protection system. The next one is ransomware protection. So this refers to the encryption of data to prevent attacks. Third one is disaster recovery as a service. So it is so when data has been compromised, improperly deleted or lost, so it allows you to restore the data. Next is copy data management. So this one, you reduce the amount of data you have with you to prevent the risk of breach. So I'll be very quick. So, okay, let's go to developing a data protection policy. So the first way to develop a data protection policy is risk tolerance. This involves balancing protection costs with data sensitivity. The next one is authorization policy. This involves controlling access to the data. So you don't just allow anyone to have access to it, and those who have to have access to it must be made aware of their obligations as data controllers. So security strategy, yeah, this involves the measures that organizational data controllers must enforce. For instance, firewalls, encryption technologies, and training staff to be sensitized about to be aware of the need for data protection. To compliance strategy. So this simply means adhering to aligning data protection strategies with laws like the GDPR and the Nigeria Data Protection Act, also 2023. So in summary, all I have been talking about are basically giving an introduction of data protection, the key concepts and the principles, and how that in the world we live in, data is on the rise and it is increasing and it is very essential, and there is a need for proper protection and awareness of its importance in this age. Yeah. So yeah, thank you very much.
Thank you,
That brings
Mr.
me to the end.
Laurel Femi. Thank you for your presentation. Thank you for stepping in to make the presentation on behalf of your group.
Yeah. Thank you.
Not to waste any time, we would like to give the floor to the mentors, right, to give feedbacks to the presentation and maybe any other further addition that they would like to add as pertaining to this subject matter. If they will have like anything, if they would like to add anything, this is the opportunity for them before we go to the question and answer segment. So we'll be starting with Mrs. Osas to just give us her feedback into the both presentation that was sent to them and also from what they had the mentees present, and also anything they would like to just generally add for the mentees or they would like for the mentees to know. So Ma, the floor is yours. You're welcome back, Ma. Ms. Osas, are you still with us?
Yes, I am. You said I should give feedback on the presentations from both groups. Right?
Yes, maybe any other general advice or information you'd like to share with them.
Both presentations were outstanding. It's very impressive to see that people can dedicate time and effort to personal growth and knowledge thanks to this institute. For any input so far, I would say this is an evolving sector, unlike other sectors that have come a long way. This is just wading through the waters. So the only thing I can even impart for myself and everyone here is to keep on growing, especially in these sectors. Things are changing, trends are happening. Keep on improving yourself, keep on reading, and keep on seeing yourself as the person that can make a change. If we all have that change or grit or growth mindset, this sector will be better than we've ever thought of it. So that's something that I can add to this. So well done to the groups.
Thank you very much, Ma, for that feedback. I'm sure the mentees are listening, and right, they would consider further research, further knowledge-based, further knowledge-based search into this particular evolving aspects of law and technology. So we would like to hear from Mr. Ridwan, if he's still with us, for his feedback, and then maybe any other additions he would like to add before we take questions.
Yes, I'm still here. Thank you, Dennis. And I thank you to Mrs. Asas again. I mean, I actually learned one or two things from our comments as well. So I would also like to commend the presenters and their team members for, a wonderful work. And I mean, it's a lot. I mean, just to talk about these definitions, to talk about the data protection principles and the legal, framework. It's and especially if it is just, I mean, if you just you're entering the field, if you're not really ingrained in the space already, so it's a whole lot of work, and that's actually commendable. I have, specific comments on some issues, but then I know we don't have lots of time, so I'll just try to mention one or two of the things that I identified in the presentation, and actually they are also, I mean, they can actually be they are dismissible in the sense that, I mean, you just, because that's actually how it is. You won't, I mean, that's why I went through the data protection principles, I mean, from the beginning till the end. I mean, from lawfulness, transparency, and fairness down to accountability. I mean, just for you to kind of familiarize yourselves with those principles, because I think one of the best things is actually to know all of them and to then go in depth into each of them, because I can tell you, I mean, when you want to talk about lawfulness, transparency, and fairness, it's a whole lot of things. If you even want to write an article, if this conversation, if this session is dedicated to just that one principle, it's enough. I mean, we could use hours to just talk about that particular principle. So there's a lot to do there. And it's also important that we kind of, understand, we kind of have a grasp of, all these things, especially when we're looking at the different rights under the data subject rights, data subject rights, or the data protection principles, as I was using as an example. I noticed from both presentation, especially from group 2, that I'm a second presenter, that all the principles are actually not very aligned. So so I think, I mean, if you want to do, I mean, going forward, when you're doing your research, what you could do is actually, I mean, probably if you can look up on, I mean, you can take courses. I mean, it would be good if you can still take courses before your classes, depending on the topic you will be discussing. That's your instructors or facilitators will be discussing with you. You can, kind of look up. You can take courses on each of those topics or general topics that you find online. Very good platforms you can learn from is Coursera. You'd find a lot of courses on that data privacy and protection. On Coursera, edX, especially LinkedIn Learning as well. It's a very good resource as well. And you can also browse online, even on YouTube. So, I mean, to get a kind of, because it might take a while before all these things will come together, before you can relate them together, before you can, apply the law appropriately. So I only wanted to mention that just for you to know, what you need to pay attention to. So in terms of the data, when you're looking at the data protection principles, these are the things that you need to these are the things that, these are the terms that are there, the principles that are there. I see that some other principles might actually not be. Maybe I should give it. Let me look at that presentation. I think I have one from my end. Sorry, I just want to see if I can quickly access it. I don't want to take much of our time, but and just for you to kind of relate with what I'm saying. Yeah, so when we're talking about data, and again, also the use of roles or the use of terminology is also very important. When we're talking about data privacy, especially that's why I like the question, that what's the difference between data privacy and data privacy? Also, you really ought to know that. So when you're talking about data privacy principles, are we talking about data privacy principles, or are we talking about data protection principles? Actually, it's data protection principles. So that's also very important. So that, and then I saw that under the data privacy principles, I also saw rights of individuals. So that is supposed to come under maybe when you're talking about data subject rights generally, or you're talking about different concepts. So so rights of individuals is actually not part of data protection. So I just want to mention all this so that you would know that you really need to pay attention to where you categorize different terms or terminologies, concepts. And another thing is, as regards the legal framework, I noticed that when I think it was group 1, when you were listing the legal frameworks, I think the best thing is actually, for better understanding and categorization, you could actually list that of the Nigerian, legal framework first, and then you can then talk about the external ones that also affects our legal landscape, our jurisdiction. So I saw that, I think you were talking about EU first, and then you also mentioned the Ghana Data Protection Act. So you could actually start from the Constitution, down to the major regulatory regulations, the NDP and the NDPR. Then you talk about specific regulations that are not data privacy specific, but have provisions of law that relate to data protection or data protection generally. So I think that would have been the best. So, but as I said, all these are not really they are not issues, so to say. And because when it comes to advising generally, so it will be very good to kind of distinguish all of these terms. That's why I just wanted to start up. So I think I'll just stop there. And again, I want to commend you guys. You really did a great work, even though it might be your first time or you're just new to the space. Also, I believe the presentation that Mr. Sasas shared with you is going to be you're going to get it from the facilitators in this. From the organizers. So I think it's also going to be a great resource for you to always refer to. So that's all I have to say for now. Thank you very much.
All right, thank you so much, Mr. Ridwan, for highlighting those things as regards your feedback on the presentation. So just to make mention of something before we go to the question and answer segment, I would like to kindly advise both groups that in the subsequent presentations, if it's possible, to cite more case laws, both local and international laws, as pertaining some of the things that you are addressing, if that would be possible, for better referencing and to give light to your presentation, so that the principles in themselves are not abstract and it just don't seem like you are just reading through your presentation, but you're actually citing related cases as to describe or to give further description to the principles and the aspects you are trying to, or the thought patterns you are trying to pass across. So that's for my own end. I'm sure they will come in handy in the subsequent sections that we'll be having. So we'll be going straight to the question and answer. If you have any question, please kindly indicate by by raise of your hand, or you can send that to the chat box. But we'll be taking the questions that Group 1 already put out, and I'll just be throwing them side by side to our mentors so that they can just address them. So the first question is, and I think Mr. Ridwan started touching on it, what really is the difference between data protection and data privacy? So I would just like to give you the full hand to just maybe further break that down, and we'll go to the next question.
Thank you very much. I mean, I always say that, it's a very important discussion to have. I mean, to differentiate between data privacy and data protection. Data privacy is also called privacy. So why even looking at the differences between data privacy and privacy on its own is, is something to also think about or consider, or to even look up. And even when we're talking about privacy, generally, we have different types of privacy. You hear about information and privacy, you hear about, so there's a lot of things in terms of the concept of privacy itself. So I won't be able to really go deep into this because I'll be leaving in the next 5 minutes or thereabouts, if you would allow me. And I would also want to I would also like to take the indulgence of Mrs. Osas as well. So if I may just quickly answer this and then talk a bit. I also wanted to talk a bit about maybe the last question, because it's a bit tricky sometimes as well. And so talking about data protection and data privacy, they are actually different. When you're talking about, it's also kind of, okay, I wouldn't say it is self-explanatory. When you're talking about privacy, you're talking about the actual rights that an individual has. So, and the essence of privacy is to give more power, more what's it called now? For an individual to have more rights, or the ability to make decisions as regards how your personal data is going to be used by anyone, an individual or an organization, even though there may be some bit of limitations to that. But what privacy really means is that's rights, or that's power that an individual has as it relates to. That's why you have all those data subjects rights in terms of how you can relate to data. So I think the best concept that has to do with privacy is that's right, my own humble opinion. And then when we're talking about data protection, that's really the real work when you're bringing. And sometimes you find a privacy professional telling you that data protection is the term or the concept in between that sits between privacy and cybersecurity. Not totally, but to a large extent. And when we're talking about, and the best way to even talk about this is the data protection principles, which we've discussed a lot. And you will find that we have the confidentiality and integrity concepts there, which relates to cybersecurity. And it's always good. I also wanted to quickly mention that it's really important for you to also look up cybersecurity. That's why we have technical, and when you're talking about technical and organizational measures, those two are mainly more of cybersecurity terms, actually. But going back to data protection is really how you protect, the personal data. It's a bit, the reason it is different from privacy, as I've said, is because privacy has to do with the rights. You ensuring that an individual has the rights to enforce their rights, so to say. And why data protection is that process of, keeping the personal data of that, it's kind of enforcing or operationalizing privacy itself, making privacy work. So you protecting the personal data of the individual, you ensuring that you are complying with privacy regulations or requirements, and all those. Or that's why most times we see data protection. We call it data protection acts or data protection laws generally. So I hope that helps. But I'm thinking of the book that I can recommend now. There are lots of books that you can. At a later time, I can probably, or maybe in further classes, I can share some of the books you can read to further, clarify these two concepts or any of those concepts. And so I also wanted to quickly make a comment on the university issue, which is very, very wide. And what is going to be helpful there is different elements or different components of data protection principles we've talked about. And actually, that is what it's about. When you're talking about how long should the personal data of ex-student be stored, we're actually talking about data retention or storage limitation. And it also goes to the root of data minimization, so which is you minimizing the type of data you process. So it actually depends on the purpose. That's why we're still going back to data processing activities or the purpose. Also, purpose limitation is there as well. Although let me even put purpose limitation. But what I'm saying in essence is that data protection principles is very, very important when we're talking about this particular issue. So you might have, because you've collected different types of personal data from the students. So depending on if it's financial information, you might want to delete that personal data probably between 2 to 5 years, thereabouts, because you don't really need those information. The only reason you might need it is if there are any issues in terms of if, there are financial related issues that the students might raise, in the future, or if you still want to, or due to internal processes. But then when you're talking about transcripts, students might need these transcripts in the future. So the best thing is actually, that's the longest data a university can actually keep, because students will always go back to the university. It could even be 50 years after you've graduated as you want to, get your transcript. So that has to be kept for a very long time, and a longer period of time. And of course, you need to also kind of consider some other things in terms of the security measures, that's will be used to keep those information more secured. And when we're talking about all that information, there are other information that might be useful to universities, but might need to be pseudonymized or anonymized if it is going to be used for analytical purposes. So there are different things that will apply to different personal data that a university is keeping. So it's really a case-by-case scenario where you look at what is in operation, and then you kind of decide. So that's why privacy is a kind of living. That's why I said it's a continuous or living issue where you might need to provide different solutions, different advice, at the case maybe. So I think that was helpful. So if you may release me now, I'd like to take my leave.
All right, so thank you so much for helping us with those questions. We're happy to have you in this particular session, and I'm sure me confirming from my own end, I was able to learn a few things, and I'm sure our mentees also were able to learn a few things. So thank you very much, sir, for being with us here. We look forward to seeing you in other classes. Thank you, sir.
Thank you, too. Bye, Mrs. Osas. Bye, everyone.
Yes, bye-bye, sir. Please, we'll just be reading the other two questions to Mrs. Osas, and we'll just have her input on those questions, and then we'll be calling it a day. So, Ms. Osas, over to you. The second question second question here is, which exact court should be approached where there is a data protection violation under the NDPA?
To that question, it will be the Federal High Court. The Federal High Court will be the one to receive all complaints concerning data protection breaches and all.
All right, Ma. Thank you very much. And I think the last question for today will be, do dead persons still have the right to data privacy and protection?
Okay, so when I saw this question, like when they're teaching you law, they say not everything is yes or no. Under the privacy laws, a dead person, deceased persons have no protection under the law. However, they can take some of not they can't because they cannot. Their family could try other laws where they could have something. Because I thought of it that if we are saying no, if there is an information that could dampen on the family, maybe put, for example, they just bring out Abacha's families, their own statement. It could put them in a state of a financial insecurity. So maybe the family or the estate of the deceased person could file So that's why we're talking about that. There might be regulations, but you can draw from other sectors, other rules, other regulations or laws to help do that. Under the privacy laws, there is no protection for this person. However, you could draw. It's just like, I'm sorry to digress. If it's for children, there might not be something tenable or strong. You could go to the child rights. If it's for what do they call it? Cyber crime or internet fraud, you can go to the cyber crimes protection. So that's my answer on that. I also want to also go to the question on university. And in addition to what Mr. Ridwan said, I believe that it depends on the school and their own code that they follow. I, for one, an alumni of University of Benin, they keep setting records for, let's say, 10 years. Some records, except let's say your transcripts that are somewhat permanent, but other like your medical records and maybe all those other aside those, they are kept for 10 years. And these I confirmed recently. So those asking the question, you could go back and look at the laws or person that are in charge of your admin in your university and ask them. That's already another way to actually develop your knowledge on the various day-to-day activities concerning records retention in universities, because unfortunately, there is no one law that states in Nigeria the level or the length of retention of records. The only laws that have something to do with that is the National Archives Decree of 1992 and the Freedom of Information Act. And they don't even prefer a retention duration. They just say that it's important to keep record. So that's that actually. So thank you.
Thank you very much, Ma, for shedding more light to the questions. Sorry, I believe and I hope that our mentees, throughout the course of the period we've had this session, I think they're about roughly 2 hours, 6 minutes. They've been able to learn from some of the things the mentors have said. So please, I would like to further encourage us to put in more effort and more work into our research. The research we do on ground will give shape to the classes we have, right? So please put in effort to your research so that when you come, the interactions between the mentees and the mentors will further reveal information that will be very helpful to you. So please pay attention to your research, put in more efforts into your research, and we always hope to hear from your presentation. With this, we've come to the end of today's session. I'm happy that we had quite a number of people on this call. Please always make sure to be in attendance and follow through. I'm sure the next 5 weeks, if I'm not mistaken, in the data privacy course will be a very interesting one. I can assure you that from the list of mentors that we have, you're going to learn quite a lot. So thank you very much for being on call. Thank you so much once again, Ms. Osas, for sparing your time. I would like to advise our mentees to kindly follow our mentors on LinkedIn and just try to build that connection with them. Mr. Ridwan has already given the free hand to connect with him and ask questions, right? You can do that with our mentors. Once you identify that you are under this program, right, the learning doesn't just stop within the circumference of these classes or with your research in your particular group. It should continue both here and without. So please, you should continue, or you should connect with the mentors, ask them questions, ask for help in any way that you can, and I'm sure they will do well to help as much as they can. So thank you very much once again. And with that, we've come to the end of today's session. Goodbye, everyone, and enjoy the rest of your evening.